Welcome to this continuing medical education activity, Extreme Risk Protection Orders, what clinicians need to know. I'm Catherine Hoops, a pediatric intensivist at Johns Hopkins Medicine and core faculty in the Center for Gun Policy and Research at the Johns Hopkins Bloomberg School of Public Health. Our objectives for this activity are to define and describe extreme risk protection orders, describe examples of applications of extreme risk protection orders, and understand the process by which a clinician can petition for an extreme risk protection order in select states. In this course, we will first provide an introduction to firearm injury epidemiology and to evidence-based firearm safety policies. We will then hear from Dr. Shannon Frateroli, the nation's leading expert on extreme risk protection orders, to provide an introduction to extreme risk protection orders, also called ERPO. Then Dr. Alex McCourt will, with his expertise in law and public health, lead us through a case example by explaining Maryland's ERPO law. Then Dr. Paul Neistat, a psychiatrist and suicide epidemiologist at Johns Hopkins Medicine, will introduce clinician petition for extreme risk protection orders and some special considerations. And finally, we will review clinician implementation of extreme risk protection orders, including some simulated patient encounters before we conclude the course with a brief review. So first, we'll review some basic firearm injury epidemiology. Contrary to what we see in the media, suicide is the leading cause of firearm death in the US. About 60% of gun deaths are suicide, and about a third of those are from a military population. Mass shootings account for about 2% of firearm deaths. The black wedge represents about 5% of gun deaths, or 1,200 deaths per year, which are unintentional injuries, undetermined intent, and legal intervention or officer-involved shootings. Something to keep in mind when we're thinking about suicide is that firearms represent a small portion of overall suicide attempts. But because they're extraordinarily lethal, with 85 to 90% case fatality, they account for more than half of fatal suicide attempts, even when they represent a small portion of total attempts. When we consider who is using firearms in suicide attempts, it tends to be older white males. Suicide risk increases in the late teen years and then decreases among Black Americans, but it increases for white Americans throughout the life course. When we look at homicide in the US, for non-firearm homicide, we're about the same as other peer nations, but firearm homicide separates us. It's 25 times higher than that of our economic peer nations, giving us an overall homicide rate that is 2 to 3 times higher. Non-firearm homicide rates we see here trending down, with a peak in 2001 representing September 11th. And we see an increase in firearm homicides beginning in 2014, likely having to do with unrest after officer-involved shootings in Ferguson, Missouri, and elsewhere, and subsequent changes in policing and policy that have caused stress in our urban communities. Similar to suicide, we see that homicide does not equally affect different racial and geographic groups. We see firearm homicide victimization rates that are 5 to 10 times and sometimes up to 40 times greater among young Black men. From a previous slide, we know that there were about 14,000 firearm homicides in 2018, but we only know the type of gun used in about 8,000 of them. When we know what type of gun is used, about 90% of the time that's a handgun. And that's the reason that many of the policies that regulate firearms beyond federal policies are specific to handguns. In 2018, there were 132 unintentional firearm deaths among individuals under 21. A third of those were among kids under 13. They're usually being exposed to these guns in the home, but these injuries aren't only happening at home. In conjunction with the increase in civilian gun carrying, we're also seeing increases in gun-related injuries among children outside of the home. This is why guns should be safely stored every time they are out of the immediate possession of the adult gun owner. The last topic we'll review is intimate partner violence, or IPV. Every year, about 600 women in the US are killed by their partners using a firearm. Guns are particularly lethal in the context of IPV. Victims of IPV are 5 times more likely to be killed by their partner if there is a gun in the home, and this risk is greatest at the termination of the relationship. Dr. McCourt will discuss more on relevant policies later. Next, I'd like to share with you a little bit about what we know about evidence-based gun policies, especially those that are most relevant to our practice as clinicians. So this is an example of some of the federal and state policies related to firearms. So federal law, we say, sets the floor, meaning there's a minimum set of prohibiting conditions that states must follow. That includes being convicted of a felony, being under a certain age, or being involuntarily committed for mental illness. And the rest is left to states to regulate. So state laws can exceed the federal floor to set policies regulating firearms. Importantly, though, 45 states have preemption laws that set a ceiling so that local jurisdictions cannot enact stronger policies than that which the state does. For those of you who haven't purchased a firearm in the past, this is a quick review of what happens when you walk into a licensed dealer to buy a gun. So step one, you submit to a background check using NICS, or the National Instant Check System. NICS uses name, gender, date of birth, and race to conduct a background check. Federal law only requires this if you're buying a gun from a licensed dealer. This is the gun show loophole or loophole for private sales with which you may be familiar. Law enforcement then has 3 days to do this check. So 3 things can happen. You're immediately approved, you're immediately denied because of something in your background, or you're delayed for further review. If that review is not done in 3 days, the default under federal law is that the sale is allowed to proceed. And it happens about 4,000 to 5,000 times per year that someone comes back as being prohibited and law enforcement then has to go and retrieve the gun. 21 states have private sales regulations that have been associated with reduced interstate trafficking, but have not been associated with reductions in homicides and suicides. But to further strengthen these systems, 9 states have required anyone who wants to buy a handgun to apply for and obtain a license. Often this includes fingerprinting. If you look to occupational licensure and the evidence supporting it, as much as 10% of criminal history information is missed without fingerprinting. They give more time to complete the background check and process the application, usually about 30 days. And no one can sell to anyone without a license, regardless of whether or not they are known not to be prohibited. This is strongly supported in the evidence to show reductions in homicide, suicide, and even fatal mass shootings, which is difficult to demonstrate given their relative rarity. A substantial body of literature shows that having a gun in the home increases the risk of homicide and suicide by as much as 3-fold, even controlling for a host of risk factors. We know that 35 to 40% of homes with children have at least one gun, and we know that over half of those guns are not safely stored. When we think about risk of suicide among adolescents in particular, 45% of fatal suicide attempts were committed using a firearm, usually obtained from a family member's home. When guns are safely stored in the home, there are substantial reductions in unintentional injuries as well as suicide and homicide. And this risk reduction is not just in kids. Safe storage is a deterrent to suicide by adults as well, since it interrupts the pathway from ideation to attempt, which is often under 5 minutes. It also prevents theft, which is an important portal of entry for crime guns. Our center, the Johns Hopkins Center for Gun Policy and Research, has conducted multiple national public opinion polls on a variety of gun policy topics every 2 years since the shooting at Sandy Hook. According to our public opinion polling, 73% of US adults support laws that would require gun owners to lock up their guns at home when not in use in order to prevent unsupervised access by children or teenagers. To that end, 18 states in the District of Columbia have passed child access prevention laws, which require gun owners to store their guns in ways that children can't gain access to them and impose penalties if children do, or in some cases could, gain access to them. But enforcement is a challenge. Law enforcement isn't going into houses to check and see that guns are properly stored, and often the lack of compliance with these laws only comes to light when someone is injured or killed. The age varies, and the degree to which they prescribe safe storage also differs. But overall, these laws are associated with reductions in unintentional injury and firearm suicide. So what is safe storage? And there are a range of options. At a minimum, all guns should be stored unloaded and separate from ammunition, but higher degrees of protection are conferred by storing that unloaded gun with an external locking device, such as the cable lock shown here, or in a locked box or drawer safe, or better yet, in a locked wall safe. While a household without a gun is the safest home from gun injuries, that's simply not going to be palatable for many Americans. And we should be prepared as clinicians to discuss a range of safety options, including gun removal when necessary. Another option that patients might have when in crisis is to transfer their firearm voluntarily to law enforcement, to a dealer, or to a family member or friend. The laws governing these type of transfers differ dramatically from state to state. but often there are background check exemptions in the context of a risk of violence or self-harm. In Maryland, a background check is required for a transfer of this kind. Interestingly, Washington State has a voluntary no-buy list that patients can put themselves on if they know they're going through a hard time. And finally, ERPOs, or Extreme Risk Protection Orders, which are the topic of the remainder of this session. ERPO have really expanded in the last few years. They allow certain individuals to petition the court to dispossess someone at imminent risk to themselves or others of all firearms. All states allow law enforcement, but the newest versions allow family members, and a few allow healthcare professionals to petition. They function similarly to domestic violence restraining orders. There's due process, so respondents come to court and present their case. If the order is issued, it usually lasts a year, but it can be removed sooner if the critical time passes sooner. Studies of these laws in states that have had them for longer, notably Indiana and Connecticut, have showed significant reductions in suicide. And new research from California suggests that they can also prevent fatal mass shootings. However, fewer than 1% of ERPO petitions in Maryland since their implementation in the fall of 2018 have been made by clinicians. Our research group, led by Dr. Shannon Frateroli, wanted to understand why. Well, after surveying about 90 faculty, we learned that 72% of us are not at all familiar with ERPO, but over 90% of us encounter patients for whom an ERPO might be appropriate at least a few times per year. The goal of this activity is to address those barriers. Now, we'll hear more about the evidence for ERPOs from leading expert, Dr. Shannon Frateroli.
Despite the fact that gun violence in this country is viewed as an intractable problem, real progress is being made. The best example is Extreme Risk Protection Order laws, also known as ERPO. Over the past 6 years, a growing number of states in the District of Columbia have passed ERPO bills into law. ERPO is a civil protection order that allows law enforcement, and in most states, family members and intimate partners, to ask the court to temporarily prohibit an individual from purchasing and possessing firearms based on that individual's dangerous behaviors and their risk of harming themselves or harming someone else. ERPO laws are based in the evidence. They're modeled after other successful protection order laws. For example, domestic violence protection order laws that temporarily prohibit gun purchase and possession are associated with reductions in intimate partner homicide. And the science about violence tells us that the best predictors for future violence are past violent behavior and credible threats of future violent actions. Preliminary evaluations of these ERPO laws suggest that for every 10 to 20 ERPOs issued, 1 suicide is prevented. This is the first type of study that's really come out to evaluate ERPO laws, and these early findings are quite promising. Violence usually happens on a trajectory. ERPO is about intervening early on that trajectory to prevent violence from happening. ERPO laws balance the temporary restrictions on gun access when someone is behaving dangerously and at risk of violence against the permanent harms that occur when violence happens. Importantly, throughout this process, there are strong due process protections in place. There are states and localities that are model jurisdictions for how to implement ERPO laws well. Our website has information about some of these model implementers. When I look at the landscape of gun violence prevention policy in this country and the possibilities for progress, I'm very hopeful. By bringing science to policy, we're getting good laws that are making a difference in our communities every day.
Next, Dr. Alex McCourt will present a case example, a summary of Maryland's ERPO law.
Hi, my name is Alex McCourt. I am a lawyer and assistant scientist in the Department of Health Policy and Management in the Bloomberg School of Public Health. I'm also the Director of Legal Research for the Center for Gun Violence Prevention and Policy. Though I am a lawyer and will be discussing Maryland law today, this information does not constitute legal advice of any kind. Over the next few minutes, I'm going to be talking about Maryland's Extreme Risk Protection Order policy. Extreme Risk Protection Orders are also called ERPOs, and I will use the two terms interchangeably here. I will be discussing Maryland ERPO law and the difference between ERPOs and domestic violence protective orders. When research and evidence are turned into law, we can make a big impact on health. ERPOs were initially developed as an evidence-based policy mechanism that could help those at the highest risk of harming themselves or others. There is tremendous potential to use ERPO laws to prevent firearm-related injuries and deaths. ERPO laws are tools for law enforcement, family members, and in a few states, including Maryland, clinicians, to intervene before a crisis moment becomes a tragedy, such as a death by suicide, homicide, or mass shooting. ERPO creates kind of a timeout. It's not a permanent prohibition from possessing or purchasing firearms, but a temporary one for someone who may be at risk of harming themselves or harming others with a firearm. So what does Maryland's law actually say? Well, it's actually very similar to most other ERPO laws. There are 19 states at the moment that have ERPO laws, and Maryland's is pretty similar to other states, but there are a few differences. It was signed into law by Governor Larry Hogan in April 2018 and took effect in October 2018. At the time, the state developed forms for petitioners and some informational materials to distribute to key stakeholders on the new law. Furthermore, law enforcement trainings took place all around the state to provide police officers and sheriff's deputies with important details on how the law would function, how petitions would be filed, and how firearms would be removed. These early measures built important relationships among key stakeholders. Maryland was the first state to include health professionals, in addition to law enforcement and family members, as authorized petitioners for ERPO. Shortly after Maryland did this, Hawaii and DC also passed laws allowing clinicians to petition for ERPOs. Today, Marylanders may petition for an ERPO 24 hours a day, 7 days a week. The district court provides access when the court is open, and judicial commissioners are available when the court is closed. They hear petitions for interim ERPO orders that can then be turned into temporary ERPO orders when the court opens back up. Basically, a commissioner puts in an interim order, and when the court opens, then the district court will hear arguments for a temporary ERPO. In Maryland, when a temporary ERPO goes into place, it lasts for up to 7 days. During that time, the court sets the date for a final ERPO hearing, and law enforcement serves the ERPO on the respondent. When they do this, they explain the terms of the order to the respondent and remove all of their firearms. They also enter the ERPO into the background check system to ensure that the respondent cannot make any future firearm purchases while the order is in effect. At the final ERPO hearing, the respondent may appear in court but is not required to. When they do appear in court, they can present evidence to refute the argument that they are at high risk to themselves or others. The petitioner, whether it be law enforcement, a family member, or clinicians, present the evidence to the court. They present an argument for why the person is a risk to themselves or others. If the court agrees and it issues a final ERPO after the hearing, the ERPO remains in place for up to 1 year. If the court does not issue the ERPO, the firearms that were initially taken away during the temporary ERPO period are returned, and the ERPO is removed from the background check system. When a final ERPO goes into place, it can last for up to a year, but at the end of that period, the original petitioner may petition to extend the ERPO for another 6 months if the person is still at high risk of harm. However, if the order expires at the end of the 1 year, then the respondent may request the return of their firearms that were confiscated when the order went into place. Commonly, people question why or how an ERPO is different from a domestic violence protection order. The ERPO process looks a lot like the domestic violence protection order process. In part, this is because ERPO policies were drafted using domestic violence protection order policies as a model. The domestic violence protection order process exists in every state and is a recognized, effective tool for addressing intimate partner violence. Though the effects of ERPOs and domestic violence protection orders on firearm access may be similar, the circumstances for each order are quite different. An extreme risk protection order temporarily prohibits the respondent from purchasing and possessing firearms and ammunition. A domestic violence protective order is also a civil order issued by a judge, but it provides various forms of relief from abuse, including ordering the respondent, in this case the accused abuser, to refrain from abuse and threats of abuse, to refrain from contacting the person eligible for relief, to surrender firearms, and to refrain from purchasing firearms. These orders may also award temporary child custody. Though ERPOs are quite new, the fact that domestic violence protective orders are effective at reducing intimate partner and domestic violence suggests that ERPOs will be similarly effective at preventing violence of all types. It also makes it easier to explain to somewhat resistant petitioners and respondents because this domestic violence protection order process has been in place for so long. While both ERPOs and domestic violence protective orders restrict firearm access and involve similar legal processes, there are key differences. While domestic violence protection orders provide broader types of relief, they focus solely on instances of domestic or intimate partner violence. ERPOs are narrowly focused on firearm access, but may be issued in response to many types of violence, threats of violence, or other risky behaviors. In addition, only those experiencing domestic or intimate partner violence can petition for a domestic violence protective order. Clinicians and law enforcement cannot petition for these orders. However, law enforcement and clinicians are authorized to petition for extreme risk protection orders in an effort to remove firearms from a person at high risk of harming themselves or others.
Next, Dr. Paul Niestat will introduce clinician petitions for extreme risk protection orders, including some key considerations for clinicians.
People are tired of seeing gun violence in their communities. Clinicians are tired of losing their patients to gun violence. ERPOs offer a common sense solution that puts the power into the hands of people who are closest to those in need of help. But implementation really matters. We must help law enforcement to know how to serve an ERPO, help judiciary know what to do when they receive an ERPO, and inform family members that ERPOs exist. It's the same for clinicians, which is the point of this activity. Next, we'll present some common clinical cases to model how ERPOs can be used by clinicians to save lives. But before we begin, a common question that arises is how does one determine when an ERPO is warranted rather than an involuntary inpatient admission, and how these clinical means of addressing risk of violence differ? Involuntary inpatient admission, also known as civil commitment or involuntary commitment, is the hospitalization of an individual with a mental disorder who needs inpatient care because they present a danger to themselves or others. And there's no less restrictive intervention, and they are unwilling or unable to be admitted voluntarily. A person may be involuntarily admitted following an emergency evaluation. In contrast to emergency evaluations, only household members, law enforcement, and a subset of clinicians may petition for an ERPO. Any person with a legitimate interest in the welfare of an individual may apply for involuntary inpatient admission for that individual. An application for involuntary inpatient admission must include certificates from 2 health professionals who have examined and diagnosed the individual with a mental disorder. Additionally, the involuntary admission hearing officer must find evidence that the individual has a mental disorder, needs inpatient care, presents a danger to self or others, or is unable or unwilling to be voluntarily admitted, and there is no less restrictive intervention available. If the individual subject to the admission application is 65 or older, a geriatric evaluation team must also determine that there is no less restrictive form of care available. An ERPO does not require the petitioner to demonstrate that the respondent has a diagnosed mental disorder. The involuntary inpatient admission process provides an opportunity for a hearing with an impartial hearing officer to determine whether the person should be admitted. This process occurs under the executive branch of government. Persons may be involuntarily hospitalized following an emergency evaluation while they await a hearing to determine whether they should be involuntarily admitted for inpatient treatment. Finally, how is the firearm prohibition different in these cases? Law enforcement may remove firearms when collecting an individual for emergency evaluation, but they must return them to the individual after the evaluation if they are not involuntarily admitted. Persons involuntarily admitted are prohibited from purchasing and possessing firearms until they petition the health department and are granted relief from the firearm prohibition. Persons involuntarily admitted to an inpatient psychiatric facility for more than 30 consecutive days are also prohibited from purchasing and possessing firearms. However, only persons involuntarily admitted and found by the hearing officer to be unable to safely possess a firearm based on credible evidence of dangerousness to others are required to surrender their firearms. Persons involuntarily hospitalized following an emergency evaluation, but before being involuntarily admitted, are not prohibited from possessing firearms.
The videos included in this module will show examples of scenarios in which clinicians could consider filing an ERPO, how to talk to patients and families about ERPOs, and the general process of petitioning for ERPOs. In this scenario, you'll see Daniel Martin, a 34-year-old veteran with post-traumatic stress disorder and depression. He was admitted a week ago after presenting voluntarily to the emergency department with his partner Lauren with thoughts of suicide. Today, Lauren and Daniel are meeting with Daniel's psychiatrist, Dr. Thompson, for a discharge family meeting.
Hi Daniel, I'm Dr. Thompson. How are you feeling today?
I'm doing pretty well, thanks. This new medication seems to be helping. I was really in a dark place before Lauren told me I needed to get some help. Thinking about killing myself, sitting and just staring at my gun. Lauren saved my life. I know I've got a long way to go, but I've got a lot to live for.
You've made a lot of progress in the last week. Do you feel like you're ready to go home?
Yeah, I think so.
I think so too. What do we need to do to make sure he keeps getting better?
Great question, Laura. Daniel, you'll keep taking your medications and follow up with your new psychiatrist in 1 week. We'll want to follow you very closely. These treatments take time, and even though today is a good day, you are at the start of a process that will likely include some dark days still to come as you make it back to full strength. There may still be more of the sort of days that brought you here, when life didn't feel worth living. That's why we made our safety plan.
Okay, I understand.
And I want to talk about your guns. I really worry about your handgun and those hunting rifles you have at home. I know you're feeling better, but again, these treatments take time. And here's why I worry. Suicide is impulsive. 71% of suicides happen within an hour of someone making the decision to hurt themselves. And the vast majority of suicides happen within 30 days of hospital discharge. How can we work together to make your home safer for you right now?
What do you mean?
Well, I feel strongly that in order to be safe at home, we need to get the guns out of the house for a while.
Daniel, you're getting better, but you're still not yourself. I don't want to be back where we were last week, but if that happens, I want you to survive it. What are the options, Dr. Thompson?
Do you know someone who could hold on to the guns for you? That's called a voluntary transfer. If your brother can have guns legally, I could help you give them to him to keep safe for you until you're better. Would that be an option?
I mean, I can give my brother my handgun, but it's hunting season. I love being outside hunting with my family. I hear you with the numbers, I do, but I really think I'm better. And I think it might make me more depressed if I can't do the things I love to do.
I don't want you to miss out on those things either. But, if you were a football player and you got a bad concussion, I'd say you can play next season. We need to focus on your health. You can hunt next season. This is life or death.
We've got to get them out of the house, Daniel. I'm still so worried about you.
I mean, this has not been a great feeling for me either. But shouldn't I be focused on doing the things that make me happy?
Daniel, I care about you and your safety. And yes, we want you to do the things that make you happy. But like I said, this is a very high-risk time in your recovery. I think it's best if I make the decision for you. I'm going to ask for something called an extreme risk protective order. In our state, doctors and clinicians can ask the courts to remove guns from the homes of people who might be in danger, to themselves or others. And when you're better, when it's safe, usually in a year, the guns will be returned. Let me walk you through the next steps.
A patient at imminent risk of suicide may need inpatient psychiatric care. An ERPO could be considered upon discharge from the hospital or for patients who may not meet criteria for inpatient stabilization. Limiting access to firearms is an important way to prevent suicide because suicide is impulsive. 71% of suicides happen within 1 hour of someone making the decision to attempt suicide. While firearms represent only a small portion of total suicide attempts, because they're extraordinarily lethal, with up to 85 to 90% case fatality, they account for more than half of fatal suicides. In this scenario, you'll meet Mark Hernandez, a 17-year-old high school junior, and his mother, Cynthia, a primary care nurse. Mark has been the victim of cyberbullying. Today, Cynthia brings Mark to the emergency department after hearing from a school administrator that Mark threatened an act of mass violence.
Hi, Mark and Ms. Hernandez. I'm Dr. Hoops. What brings you to the emergency department today?
I didn't know what to do. Mark needs help.
Mark, we're here to help you. Tell me more about what's going on.
Well, this group of kids at school have just been cruel to Mark for the last year. For absolutely no reason. Mark is the sweetest young man. They've been posting mean and untrue things about him on social media. It's just been really upsetting for Mark and for all of us. It feels like his bullying is nonstop. They post all this stuff online and then laugh at him when he's at school. It's really demoralizing for him. I don't know how much more he can take. We had a meeting with his school principal and teachers about it a couple of weeks ago, and the student was suspended, but...
Yeah, and that just gave him more time at home to make fake videos of me.
Oh, that's awful, Mark. I'm so sorry.
Well, the bully posted an awful, just awful video of Mark online, and...
It feels like the whole world saw it.
Yeah, and Mark is the nicest boy. Such a good student and friend. But this kind of meanness would get to anyone.
Mark, how do you feel? Your mom is right. This would be really upsetting for anyone.
Yeah, it's upsetting. I mean, I hate this guy. And that video was fake. It wasn't even me. But he makes it look like me. I got really mad, and I told my best friend that I wanted to kill him. But I didn't mean it. Not like I'd be sad if he died, honestly. But I wouldn't hurt anybody.
It's totally normal to be furious. But of course, your friend and your mom and your teachers are worried that normal anger might drive you to do something that's totally unlike you. Can you tell me more about that?
I didn't mean it. I wouldn't hurt anyone.
I know you think you wouldn't, but Mark, you've not been yourself these last few weeks. You've been so withdrawn. I'm worried about you. And Dr. Hoops, after I got the call from the school informing me that Mark's friend had told the school's guidance counselor what Mark said, I went and looked in my son's room. I noticed several violent drawings on his desk, and I found a list. He printed off all the comments from that awful video and made a list of all the names of the kids who had made mean comments on it. I was shocked. I was so shocked.
You what? How could you go through my stuff?
Mark, I love you, and I'm scared for you. I'm afraid you aren't yourself and you'd hurt someone.
Mark, Ms. Hernandez, thank you for sharing all this. Mark, I'm worried about you too. And I definitely want to have our psychiatry team come and talk to you about these feelings. And when you go home, if that's today or after a few days of treatment, I want to be sure that you're safe. So I have a few questions to ask.
Anything.
Are there any guns in your home?
Yes. My husband owns 2 hunting rifles. He's out of town right now.
We need to get those guns out of the house. And since Mark is 17, almost 18, we need to make sure that we keep him safe during this really difficult acute period. Mark, because of the stress from this bullying, you're in danger.
No, I'm not. I just got mad. Anyone would be mad.
Of course you're mad. But you've been different. Your artwork has been really dark. And that list, Mark, that scares me.
I'm not going to hurt anyone. It was just an expression. You're overreacting.
Your friend had to tell someone. Your mom had to tell someone, and I have to tell someone too. I'm going to ask the police for their help in getting the guns out of your home and preventing you from getting new ones during this crisis. To keep you safe while we're all really worried about you. I'm going to ask for their help petitioning for something called an extreme risk protective order. Have you ever heard of this before?
No, but my husband keeps them locked in a safe and unloaded, so I don't think Mark can get to those. Safe storage and safe handling is really important to my husband and our family.
In our state, police and law enforcement can ask the courts to remove guns from the homes of people who might be in danger, to themselves or others. And when you're better, when it's safe, usually in a year, you can have the guns back. And it doesn't matter that Mark doesn't own these guns. If he has access to them, they're a danger. Mark is smart and resourceful. And even though you store your guns safely, I still think this is important.
No, you're right. And I don't have anyone I could give them to. I want them out of the house. I think my husband would agree.
Okay, great. Let me walk you through what will happen next.
70 to 80% of school shooters under age 18 acquire the firearms used from their home or from the homes of friends or relatives. But there are often warning signs. In 77% of school shooting incidents, at least one person knew about the attacker's plan. So ERPOs can be used to protect children too. Although children are not the legal gun owners, the guns they have access to may still be removed from the home during a critical period. An ERPO can also prevent purchase of firearms if a young person is about to be of legal age to purchase firearms themselves. In this scenario, you meet John and Gloria Anderson and their daughter Alex. John has Alzheimer's disease. They've contacted their primary care doctor, Dr. Vaughn, after John brandished a firearm and threatened someone the previous day.
Good morning, everyone. I got your message. What's going on?
They're all in a tizzy after I got a little confused yesterday evening. It's nothing.
Dr. Vaughn, the last time we talked about my dad's dementia getting worse, we had decided to start working on all the power of attorney stuff, and we've been working with our lawyer on that, but it's still not finalized. We had also talked about looking into assisted living facilities, since he's been having some more problems getting around on his own at home.
Y'all are just trying to get rid of me.
Dad, we just want you to be safe. And well, he's had some more volatile behavior lately. Mom, do you want to tell Dr. Vaughn what happened?
Well, John gets confused and becomes quite agitated at times. He was really confused yesterday evening. He had been in our bedroom lying down before dinner when he saw the mailman come up on the porch. He thought that Arthur, who has been our mailman for years, was trying to break into the house. He grabbed the handgun that he keeps in our bedroom and came out threatening to shoot him. Even after he saw that it was Arthur, he kept at it. I thought he was going to kill him.
It was an honest mistake. He didn't even have a package. I was trying to protect my family. I was a cop, for God's sake.
John, I know you want to keep your family safe, but that's worrisome.
Don't be ridiculous. It was an honest mistake.
So, John, you know when you first got diagnosed and we talked about how one day we'd need to talk about your safety and that Gloria would eventually have to help make the decision about when it was time for you to stop driving. And last year, we decided it was time for that. Well, just like cars, guns become more dangerous when you have this diagnosis. And just like your driver's license, for your safety and everyone around you, you and your family have to make the decision when it's time to not have access to those things.
I've had a gun for over 50 years. I was a cop. I have a right to protect my family.
But John, we need to protect you too.
Y'all are just trying to get rid of me.
No, we're not, Daddy. We love you. You really scared us.
I'm so sorry. It seems like I've waited too long to have this conversation. So I'm glad you reached out to me so that we can have it now. You already had to make the decision to take away his driver's license, which I know wasn't easy. It's not your job to wrestle away these guns, too. Let me be the bad guy here. I'm really worried that the worst could happen here, that he could hurt himself or someone else. I'm going to ask for something called an extreme risk protective order. In our state, doctors and clinicians can ask the courts to remove guns from the homes of people who might be in danger to themselves or others. Let me tell you what happens next.
Just like cars, guns can become more dangerous for adults with dementia. Firearm safety should be part of routine counseling provided at all stages of the life course, but especially in the context of aging and dementia. Each scenario concludes as the clinician is about to describe our next steps. Let me now walk you through those next steps. The specific process varies by state, but the general approach is very similar. First, the ERPO petition is completed and filed with the court. Only the petitioner and not the respondent needs to be present at this time. Then, the temporary ERPO hearing is held. In this hearing, the petitioner presents to the court explaining why they believe the respondent is at risk. Based on this hearing, the judge may issue a temporary ERPO. After the temporary ERPO is issued, law enforcement serves the ERPO. They provide the respondent with a copy of the order and explain the terms. The respondent must then dispossess themselves of all guns and ammunition. Law enforcement then adds the temporary ERPO to the background check system to prevent firearm purchases. Next, the final ERPO hearing will be held. The petitioner presents the petition to the court and the respondent responds. The court then determines whether to issue a final ERPO. If the court issues a final ERPO, the order may be in place for up to 1 year, although the respondent may return to the court to request termination of the ERPO. When the ERPO ends, the respondent can request the return of firearms. If the respondent is not otherwise disqualified from having firearms, They will then be returned, and law enforcement updates the background check system to allow new firearm purchases. So in summary, clinicians commonly encounter patients at risk of harm to themselves or others. And ERPOs are an important means by which clinicians may be better able to protect those patients. Clinicians are eligible to petition for ERPOs in some states, but in states in which clinicians cannot directly petition for ERPOs, they can contact local law enforcement for help protecting patients at risk. Thank you for joining us in this module on clinicians as petitioners for extreme risk protective orders.